name is David Wright. I'm the chair of the Law Society Tribunal, and I'm delighted to welcome everyone both in the room and on the webcast to the last session of TAG's Access to Justice Week for 2018, Mental Health, Access and Ethics. This session was made possible thanks to the support of the Action Group on Access to Justice, also known as TAG. With funding from the Law Foundation of Ontario and the Law Society of Ontario, TAG works with a range of justice stakeholders to develop meaningful, public-centered solutions that advance systemic change. Each of the past several years during Access to Justice Week, we have included a session to highlight different issues related to mental health in the justice system. In the last couple of years, our focus was on mental health issues and how they affect justice system professionals, lawyers, paralegals, judges, and others. This year, we're shifting our focus as we want to turn our attention to the people in particular to focus on the people the system serves and how it serves them. What is the lived experience of users with mental health disabilities? How are our institutions set up to accommodate and serve those users? And what can we do better in that regard? We also want to take the focus away from just courts as the institution we focus on. It is a trite but important reminder that most Canadians' contact with the justice system is far more likely to be with the administrative justice system than the courts. Administrative tribunals are specialized. And they're what deals with the majority of legal issues that Canadians deal with. There are some tribunals, in particular one you'll hear about today, that have a system designed for mental health issues. But mental health issues and the effects of the law on people who have mental health disabilities may come up in all kinds of tribunals, as well as courts, and those tribunals may or may not have the systems, training, and tools to deal with them. And I think it's important to recognize how extensive issues involving persons with mental health disabilities are and can be across the justice system, and in particular the administrative justice system. In labor tribunals, issues of duty to accommodate in the workplace, issues of what the factors are that are taken into account when decisions are made about people's employment can be critical. The Consent and Capacity Board is a specialized tribunal, as you'll hear today, that deals with issues of consent to treatment and other related issues. The Ontario Review Board hears yearly applications from individuals who have been found not criminally responsible by reason of mental disorder and deals with their liberty interests on a regular basis. The Workplace Safety and Insurance Board deals with issues, and the Workplace Safety and Insurance Appeal Tribunal deal with issues about whether workplace injuries or workplace disabilities that are affected, that may be caused by mental health disabilities stem from the workplace. The License Appeal Tribunal deals with all the effects of automobile insurance accidents. And those of us who work in professional discipline often deal with the extent to which mental health disabilities should affect people's admission into professions, people's ability to continue to practice their professions, and the extent to which that is a mitigating factor where they're accused of misconduct. So part of what I want to emphasize at the outset is just the broad nature of the extent to which mental health disabilities affect our legal system. And what we want to do today is have a conversation between you and us and between three people who come at that issue from different perspectives. In terms of your comments, those of you who are on the webcast can put any questions or comments into your live event interface, and we will take them closer to the end. Those of you who are in the room, we will have cue cards in which we ask you to write down the questions or comments, and we'll put them to our panelists. But today really is a conversation among our panelists in which we'll be moving back and forth between different topics as opposed to having them do formal presentations. Let me begin by introducing each of our panelists. To my far left, Tess Sheldon is an assistant professor at the Faculty of Law at the University of Windsor. She writes, presents, and teaches extensively on a variety of mental health, access to justice, disability, and human rights topics. She recently completed her doctorate at the University of Toronto, exploring the legal issues raised by the covert administration of medication in psychiatric settings. And prior to becoming a full-time academic, she practiced extensively within Ontario's legal clinic system, including at Arch Disability Law Centre and Justice for Children and Youth. Our next speaker is Jennifer Chambers, who's Executive Director of the Empowerment Council, which is a systemic advocacy organization run by and for people with histories of mental health or addiction service use. The EC is the only such organization in Ontario regularly acquiring standing at inquests and intervener status in precedent-setting legal cases. And I understand that actually as we speak, we've pulled Jennifer away from a fascinating case in the Court of Appeal where the Empowerment Council is intervening about the extent to which the Consent and Capacity Board can order certain treatments as ancillary treatment. So that's just an example of the breadth of the work they do. Jennifer is co-chair of the Mental Health Panel of the Toronto Police Services Board, and she's vice chair of the Ontario Association of Patient Councils. Our third panelist today is Nina Lester, who's a vice chair of the Consent and Capacity Board of Ontario. The CCB is an adjudicative tribunal whose mission is the fair and accessible adjudication of consent and capacity issues, balancing the civil rights of vulnerable individuals with public safety. Its key areas of activity are the adjudication of matters of capacity, consent, civil committal, and substitute decision-making. And in addition to presiding at hearings and writing reasons for decisions, Nina is involved in public outreach and training new members of the CCB. Prior to her current position, Nina practiced corporate law and was a legal analyst for the Environmental Commissioner of Ontario. She has a law degree from the University of Toronto and was called to the bar in 1988. So I think we're going to have a fascinating conversation from the perspectives of, from an academic perspective, from a client perspective, and from the perspective of those who are on the front lines making these decisions every day. And of course, no one's perspective is exclusive to those because I know you've all worked in different capacities. So let me start, but just by asking you to tell us a little bit more beyond that introduction about the nature of your work and the nature or the nature of the work of your organization on these issues. How have you come to this topic? Why don't we start with Jennifer?
My organization consists entirely of people who have personal experience in mental health and addiction services. We're systemic advocates, and we're funded by the Centre for Addiction and Mental Health. We take direction for our policy from our members. We get funding from the centre, so we try and operate with a little conflict of interest as possible under those circumstances. We have been parties at an inquest in someone who died at the Centre for Addiction and Mental Health. That was especially hairy, but we thought that it was important that we be a voice for clients at that inquest. So we, as mentioned, are the only group of our kind that appears at inquests and court cases. It's important that we're there because the courts and the juries need to understand the broader implications of what they're going to be ruling. And they tend to be quite grateful to hear about that from us. So sometimes in inquests, we're the only people who are speaking to the same concern that the juries in the corner have, which is to prevent future deaths of our community members. We also speak at inquests so that people can understand the issues broader than the particular person who that case is about. I think that initially the coroners and the judiciary were hesitant to hear from us. They thought we'd be there to sort of being ideological, but we're in fact very practical and make quite down-to-earth suggestions. So they're actually, some people have expressed a lot of gratitude for our involvement. Juries, too, I find that when I testify, juries tend to be quite interested in asking me questions that they've been maybe saving up. They want to ask somebody, and I seem kind of like the everyday person that they can ask. So I've been asked, would you rather be tasered or beaten? I said, well, I'd rather have a conversation. Failing that, whatever's least likely to cause my death. And I was asked whether there's somebody who was in crisis because he was constantly having to deal with people overhead that were very noisy and keeping him awake at night. And so one of the jurors asked me, why didn't they just change his room so that the people above him were down in his room? I thought, very sensible. I don't know why they didn't do that. And they asked me, why can't police meditate and things like that. I think with courts, we probably have our established history probably helps us get standing. They vary in how much credence they give our perspective. There's some justices that are slavishly devoted to the medical model, and even if a psychiatrist has no or maybe one poorly done study published, and somebody else has a vast array of well done articles as an expert in the area, they don't tend to give as much credit to them. Some justices, if they don't have a medical degree. I find the Supreme Court the best in this regard. I think they seem to have more confidence in their own ability to assess information and to evaluate arguments as they come before them. And of course, because we almost always win before the Supreme Court, they recognize that we are usually right. And on the side of rights, we're right in every way except leaning. It also helps that we've had so many brilliant counsel representing us. We work a lot with Anita Seghetti. We've also had people like Tess and Karen Spector, Mary Birdsall, Aaron Deere, Marshall Squadron, Susan Fraser, Mercedes Perez, Kelly Bryant, Alice Prosope, Paul Burston. Here's a long list of brilliant people that we've been lucky enough to have represent us. Could go on, but I'm mindful of your time. It makes a big difference to work with people who understand our values, because when people are questioned, they have to understand on their feet what we mean by certain things. And early on in our doing this, we had some problems with that. People would give answers that I'd be groaning about sitting in the audience, but that doesn't happen anymore. And as a result of our involvement, the Toronto Police Service has changed many policies and practices, and mechanical restraint use in Ontario has changed. Our access to the courts is also possible almost exclusively because of the benevolence of group and test cases with Legal Aid Ontario. So we are so grateful for that. And we also have pro bono work whenever we have cases. And once we had funding from the Court Challenges program, which funded us both to survey forensic clients across the country, which is the first time that had ever happened, to identify what their priorities were, and then to pick something to prioritize. It wasn't something legal counsel would ever think of. It was about people's desire to get the help that they actually feel they need when in the system, so they can at some point leave the system. And that ended up becoming a case called Matsai that went very well.
Jennifer, I'd be interested in how the Empowerment Council got started. Who did it start from the ground up? How did you get the funding from CAMH? For
the council itself?
Yeah.
We actually started as the Queen Street Patient Council, and there is a national meeting, sort of the one and only time, people across Canada met who'd had personal experience of mental health services. I, at the time, was leading a support group for mental health oppression survivors, I called it. And it was apparently the only one around, so I got invited. I was a grad student at the time. And then the Ontario government was interested in hearing from someone who spoke from Holland about patient council. So they started funding us. I was involved in creating the first patient council. And then when the Centre for Addiction and Mental Health was formed, they decided to create one that represented people in all 4 sites.
Great, thank you.
I create them, then I work for them. It's really the ideal working situation.
Good advice for people in building community organizations. Nina, can you tell us a bit about how you come to this topic and about the work that you do?
Yes, thank you, and thank you for inviting me. It's a pleasure to be here today, representing the Consent and Capacity Board. Many of you might have never heard of it. I had never heard of it before I applied for a job there about 10 years ago. It's a tribunal, which is a quasi-judicial body that hears applications and makes decisions. We receive applications from psychiatric patients who wish to challenge the decisions of their doctors. Sometimes decisions are imposed on patients against their will. For instance, a civil committal, which means that a patient's going to be detained in a hospital against their will for treatment. And again, sometimes a doctor will find a patient is not capable of making their own treatment decisions due to mental disorder, and will seek consent for treatment from a substitute decision maker. So that is also imposed on the patient against their will. So thanks to the Canadian Charter of Rights and Freedoms, which says that people should not be deprived of their civil liberties, except in accordance with the principles of fundamental justice, So there's an application process whereby these patients can seek a review from my board, the Consent and Capacity Board, to review the doctor's decision. And it's an evidence-based hearing. So we ask the doctors to present us with evidence as to how they came to their decisions, and the criteria are set up in certain statutes. So I'll just describe the statutory framework. The most important statute in our work is the Healthcare Consent Act, and that was enacted in 1996, and it creates the Consent and Capacity Board. So we're a creature of statute, as most tribunals are. And so the Healthcare Consent Act deals with issues of capacity in three major domains of decision-making, the first being treatment, the second being admission to a long-term care facility, which is otherwise known as a nursing home, and the third being management of property, so like financial decisions. So a doctor can take away those three areas of decision-making from a patient. The other important statute in our work is the Mental Health Act, and that's the statute that allows doctors to detain patients who are in need of treatment or supervision. We have some other statutes that I won't go into today that assign other types of hearings to us, but they're much less important in our work. So I'll focus on those too. First, I'll just talk about our membership. We have about 150 members on our board, part-time members. So most of our hearings have panels of 3 people sitting as panel members. There's usually a lawyer. There's always a lawyer who is the presiding member, and then a psychiatrist and a member of the public. So those are the 3 types of panel members we have. The psychiatrist members, that category has now been opened up to, frankly, because we were having a shortage of members. It's now been opened up to any medical doctor and nurse practitioner who qualifies. So most of our hearings have the panel of 3, and how does a matter come to a hearing? I'll talk about that a little bit later. I do wish to just mention that we have a very intensive training program for new members that join our board. We have 2 full days of classroom training for the medical members and public members, and then a 3rd day of classroom training for the lawyer members. So because we're attracting people from all sorts of different fields, most of our members do not have prior experience dealing with mental health issues. This is new to them, because not all of our medical members are psychiatrists, and certainly our public members come from every walk of life, and our lawyer members too come from other areas of practice. So for instance, I was a corporate lawyer before I became a member of the Consent and Capacity Board. So we have a very intense training for everyone to sort of become familiar and sensitized to the issues revolving around psychiatric patients and people with mental disorder and how to serve them well. We take it very seriously that we are public servants and we are serving this clientele, and we're there to provide a kind of like something like a watchdog agency to oversee doctors' decisions and make sure that they're not making their decisions arbitrarily or hastily and without evidence. And so our training really reflects that. Is there anything else I can talk about now?
It's good.
Okay.
Thank you. Tess.
Yeah, thank you, David. Thank you, Nina. Thank you, Jennifer. Thanks for having me. In my work, I've been struck by this idea of a pendulum that's often used as a metaphor to describe the polarity of mental health law. So on one side of that pendulum is this idea of easy interventionism, sort of based on paternalism, and it's used to justify or defend coercive legal regimes or interventions. And then on the other side of that pendulum is the vigorous assertion of autonomy and the right to refuse unwanted treatment and the ability to assert one's preferences. So usually boils down, the resolution of problems, it usually boils down to trade-offs. How far can we impinge on individual rights in order to protect the public's health? So what's been animating some of my work, what's been inspiring me, is this prospect of recalibrating that pendulum, reshifting the debate between individual liberty and paternalism. So somewhere in between those poles is this presumption, actually this, it's clear that rights are actually good for your health. Rights are good for your health. That if you give people the things that they need, the rights that they need at work and their homes, they get better, and you don't need to resort to that, one side of the pendulum, coercive interventions. And, paying attention to the systemic and contextual barriers to a home, a job, and a friend. That's something, a home, a job, and a friend is something that you kind of hear about from mental health policymakers, home, job, and a friend. That if you pay attention to those barriers to access to a home, a job, and a friend, you remove barriers that prevent people from being well in their communities. So these rights, to a home, a job, and a friend, they're actually more likely to be at stake in those administrative tribunals that David mentioned at the outset, like the Landlord-Tenant Board, like the WSIB, like the HRTO, in fact, and the CCB, I think. So my observations will flow from some thinking I've been doing about that pendulum and how rights are actually good for your health. And my observations will also flow from my background as a legal aid clinic practitioner, including at Arch Disability Law Center, where there's no doubt, absolutely, that people with mental health disabilities face disability-related barriers in their access to courts. We just know that. But as David mentioned, people with mental health disabilities are more likely to seek remedy in administrative tribunals. But they face a wide array of disability barriers in relation to that access to administrative justice. So not just at the CCB, but at the HRTO and the LTB. And one particular kind of barrier is our barriers to access to remedies. Barriers to access to remedies at administrative tribunals, including at the CCB, and that was the subject of a really exciting Court of Appeal case in PS versus Ontario. I'll also just touch a little bit, I hope, at some point on my work at Justice for Children and Youth, where I got to work with Jennifer, where the EC was a party at the inquest into the death of Ashley Smith. And so Jennifer successfully persuaded the jury in that case to adopt trauma-informed approaches, to recommend to this Correctional Services Canada to adopt trauma-informed approaches that focus on reasons that underlay Ashley Smith's self-harm rather than overly focusing on stopping it. So trauma-informed approaches. Thank you.
Thanks, Tess. So let's dive right into some of the meat of the topic now. What are we doing well in our justice system, and what can we do better in how we serve and provide access to justice for people with mental health disabilities? And what impediments are there to making needed changes? And let me start with you on this one, Jennifer.
Well, first and foremost, you're doing well at funding us and our legal counsel, representing people who try to ensure mental health laws, charter, and human rights code compliant. In fact, one of our cases was specifically about that. So being heard and represented by legal counsel in the court is actually a rare experience for somebody in psychiatric custody who can have their perspective very much ignored. I know of voluntary associations of lawyers who practice mental health law, like Law and Mental Disorder Association, Mental Health Legal Committee, and they're good for mentoring and supporting lawyers who want to practice law. They've been involved in a substantial number of cases that have moved case law forward. In fact, even as we speak, couple of the members are arguing in court. And outside of such auspices, I've encountered lawyers who don't seem to understand that their job is to represent the will of clients, but instead take a sort of best interest perspective, which is a perspective that's anathema to anyone who's got a disability or is considered to have a disability. I met a lawyer who described herself as a case manager. I said, oh, who's their lawyer then? They have case managers. I was told of by a CCB member of a lawyer who has a little signal that she gives them if he doesn't really think that their client should be released, no matter what he says. And she goes, isn't this great? And I said, no, that is horrible, and that person should be disbarred. There are many, many people who are willing to act in the best interests of people, but they have often one who's willing to speak for them, and that's their lawyer. There's also a bias in materials that comes before boards and courts, in that there's often a tendency to describe people negatively. Like I said, the people who work in hospital units frequently lean towards the negative descriptions. And the good news about that is that there's a new initiative happening that's supposed to specifically encourage people to write something positive about the clients once in a while. And it's kind of sad that this had to be like specifically laid out in policy, but great that it's happening. An example of what can happen in those sort of situations is there is someone I knew who's in the forensic system, NCR, and he had told his psychiatrist one day that he could do magic tricks, like he learned how to do them. So the psychiatrist wrote down that he thought he was magic. And then that ended up in his file and followed him around. The new electronic health records are kind of good and bad in that respect. They're kind of more encouraging. The person can see them more easily so they can make corrections to such things. But also it means that things will follow people more easily and readily around, like mistakes like that. So there's pre-charge diversion in case people is an option that actually exists for people. A lot of people don't know about because it's a police option, not a lawyer's one. We prepared a tip sheet some time ago with LAO that to give to clients on what to expect from your lawyer, basically what they have the right to expect from their lawyer. I don't think it's really handed out much anymore. We had trouble getting people to hand it out in the first place. But it would be great if we were able to get that around more. We find that the tribunals, like CCB, tend to be weighted heavily in favor of medical testimony and much less so in terms of counsel representing clients. ORB is somewhat more formal, a little bit better in that regard, but it also exceeds the narrow guidelines that were set out in WINCO for restrictive custody. That was our very first case, was the case that became WINCO. In all cases, legislative committees creating the law tend to be very disregarding of the rights of people, especially people found NCR. I was addressing a legislative committee about how victim impact statements are a violation of the charter for people found NCR. It's the same as if somebody accidentally ran somebody over because they had a heart attack, it wasn't intended, but they didn't care. They're catering to the public prejudice, and that was that. I think that the members of all the tribunals and legislative committees really need to have misconceptions and stereotypes addressed. The criminal defense bar needs a better understanding of the implications of someone being found NCR. They often don't give people an accurate understanding of what's going to happen. They'll say, oh, a little while in a nice hospital, a few months in a nice hospital. Years later, I can tell you, people are hating their lawyer because it's 2 years later, they would have been out, maybe after 6 months, and they're still in custody. The exception is people who would have done a long time, in which case they're usually in a better physical environment, and for them it's not so bad. The CCB has had province-wide consultation with doctors. They have, and their counsel, they have 2 advisories for physicians, one with counsel, one unrepresented, and they have nothing for advice about clients or counsel representing clients. The ORB meets regularly with Forensic Directors Group. Never that I'm aware of have they consulted with our community and our advocates, which is fairly, I think, blatantly discriminatory. And on that happy note, I'll finish my part with this question.
Let me ask you just a couple of follow-ups on parts of that. I'm intrigued by your, from the point of view of a regulator of legal professionals, by your point about lawyers who see themselves as case managers rather than the doing the role of the client, following the instructions of the client.
And also, I forgot one other instance where lawyers will cater to the will of the families who pay them rather than the client they're supposed to be representing.
How much is that? So, taking for a moment that a lawyer obviously has to follow their client's instructions or resign from the file if they feel they can't. Can you talk a bit about how, from your perspective, those discussions in the back room should happen? In other words, it is the role of the lawyer, I would suggest, to say what you're doing may not be in your best interest. I will take your instructions. Do you have thoughts for our audience on how to navigate that conversation in the room with your client when you're representing someone?
Yeah, I think that the concept of informed consent, which exists for the medical profession, which they don't follow either, should be applied to the legal profession as well. So as you said, to give people their best understanding of the implications of different ways that they could make their case, either different rulings that they're going after or ways of making the rulings. Like sometimes it involves telling a client, this is what I think the repercussions will be if you're testifying or you're not testifying. And people will still make a decision that may or may not follow the advice, but people should, first of all, the criminal defense bar should find out what happens when somebody's found NCR, because sometimes they don't go on to represent them before the ORB, so they don't really know. And they should find out that people tend to be held in custody much longer, for example, and tell people that that's going to be the result. Tell them they'll probably be held under better conditions than they would if they went to jail, but that they're going to be in custody probably longer. And then give the person the opportunity to decide accordingly.
And to follow up on one of your other points, you talked in particular about the use of language and the use of stereotypes by the decision makers and by lawyers. Can you elaborate just a little bit on what you say what should we be avoiding, what language should we be using, what language should we be choosing, what stereotypes should we watch out for? Not to reinforce the stereotypes, but how should we train our minds to do a better job?
Not the language so much, people have gotten better on that, but one of the biggest biases is a confusion of compliance with capacity. So we actually had a case on this before the Supreme Court, which we won. So Starson, he's known as Canada's beautiful mind, a brilliant person who said that psychiatric medications didn't help him. And I believe the evidence was that he was quite correct about that. But he argued to the court that if he refuses psychiatric medication, that's considered implicit evidence that he's incapable. So he was saying, I'm in a catch-22. I can't refuse and be considered capable. So basically, there's no way I can legitimately say no. And the court accepted that that was the case, and that continues to be the case. So you can have people who maybe have very little understanding of what's going on, but if they're compliant, they don't get judged incapable. But if they don't agree to take medication, then they're judged much more likely to be judged incapable. And I don't think the CCB recognizes that this bias happens. And I also think that there's biases about the treatment itself. There's a far lower efficacy rate for psychiatric medications than is popularly believed. They're in no way a magic bullet. They do help some people, for sure, but there's lots of other people they do not help. So it shouldn't be over-assumed that somebody is irrational in saying that medications in general or a particular medication don't help them. Like we had one CCB case that I was a witness at that was about somebody who said, this drug makes me really sick. And it was in fact a drug that can destroy your immune system and make you quite sick. In fact, can kill you. And she was saying, I'm not saying I won't take a drug, I'd just rather take this other drug. But she was overruled. It was mandated that she continue on the drug. It did indeed make her very sick. And then she was shortly after having to be taken off the drug. It was a very dangerous situation because her white blood cell count went very low. Should never have happened because it was the second time it happened with her. But things like that, just an over adherence to medical opinion without understanding that patients are actually often the best judge of what helps them and what doesn't. And similarly, the patient should be consulted always on their disposition and their treatment, because there is evidence that there's a better outcome if you base treatment on what people are saying they need rather than what service providers are saying that they need.
Thank you. Nina, from your perspective, what are we doing well? What can we do better?
Well, certainly I would agree with Jennifer that Legal Aid Ontario plays a very important role. They do fund legal representation for any applicant that comes before the board, and that's extremely important. And about 95% of our applicants take advantage of that offer and do have legal representation. And I do want to point out, though, that in 95% of our cases, the doctor party is not represented. So there's a little bit of an uneven playing field there because it's an unusual power dynamic. Yes, the doctor has a certain power position over the applicant, but at the hearing itself, the applicant has counsel and the doctor doesn't. So it's tricky for us, but we do our best to balance that out. Another thing that I think is something that has been done very well is to impose strict deadlines and timelines in our legislation, our enabling legislation. So the Healthcare Consent Act provides that when the board receives an application, the hearing has to commence within 7 days. I don't think there's any other tribunal in the province that I know of that has such a strict timeline. And I would say that we have about 7 staff whose entire job is dedicated to scheduling the hearings. And it's difficult for them to arrange a hearing room, to get the parties on side with a mutually available time, and panel members as well. And in any given day, we have about 8 panels going across the province, half of them in Toronto, and each panel hears about 3 cases a day. So our caseload is very high. But I think it's really important that our legislation has those deadlines so that these matters can be decided expeditiously. I mean, when somebody's being detained against their will, it's a very serious matter, and we have to get on it right away. As well, once the hearing has concluded, our decision has to be rendered within 24 hours, even if it's a weekend. So if the hearing concludes on a Friday afternoon, our decision has to be rendered on the Saturday. And we have to deliberate and come to our decision. And then if we don't automatically issue written reasons for decision, but if they're available on request, and if a party requests written reasons, we have to issue them within 4 days. So it's a very time-pressured job, but I think that that's a good side of the legislation. I think that's absolutely necessary. And I think another aspect that is positive is that, as I mentioned earlier, our tribunal developed expertise in this area, and rather than these matters going to courts where you don't know what the background of the judges, I think every specialized tribunal develops a specialization in that area, as well as sensitivity to our clientele. So we really try hard to be educated and up to date on that front and represent our clientele well.
Thank you. Tess, from your perspective, what are we doing well and what can we do better?
Well, both Nina's comments and Jennifer's comments reminded me of this idea that there's the difference between the law in action and law on the books, right? So even if we have great policies, great standards, it's really about what actually happens on the ground that matters, right? So if on the books everything looks good, it's really the real thing that we need to pay attention to is what is actually happening to people. So when Jennifer was talking about instruction and how lawyers get instruction, we know it is very clear that lawyers must take instruction from somebody. Client-centered advocacy is important. You have to get instruction from someone, even if it's a litigation guardian, for example. But that's not always what happens, right? We know that lawyers need to pay careful attention to whether their client has capacity to instruct. They can't become their substitute decision maker. Really careful attention needs to be paid to who's the client. It's not the family member, right? Unless there's been some kind of appointment made, right? So that's something that on the ground, I think doesn't actually play out, doesn't actually happen. And so I think there does need to be a lot more training about what do we mean by capacity to instruct, and make very clear that capacity has nothing to do with compliance. So even if your client, let's say you're a lawyer, and your client disagrees with you, that doesn't mean they're incapable, right? Capacity is not the same thing as making a wrong decision or making a foolish decision. And also, capacity is also issue specific. It may be that a person is capable of instructing you on one legal issue, but not another legal issue, right? So capacity is issue specific. It can also fluctuate. It may be that your client is incapable of instructing you at particular times, but then not at others. I think, though, at the same time, it is my experience, and I think others would agree with me, that the question of capacity to instruct doesn't actually come up all that often when, for those who practice disability law. One other thing I did want to say, if I have time, was that one impediment, I think, to making changes is over-medicalization, right? Law isn't very good at sharing sometimes. I think this is something that starts in law school, where we are taught that law can provide all the answers. And certainly it's always a benefit if we can cooperate with other disciplines, but the danger is if doctors start to make legal decisions, right? So Jennifer mentioned the medical model versus maybe the social model. So the medical model characterizes disability as like something wrong with a person, a physiological or physical impairment, and there's an aspiration to cure the person, that there's something wrong with them. But a social model, on the other side, thinks about mental health disability as something that may be at least in part caused by societal barriers. So like access to, for example, a home, a job, and a friend, the mental health, the determinants of mental health, a home, a job, and a friend. So proponents of the social model, they would perhaps be concerned with current trends in administrative justice, admin tribunals, about the over-reliance on medical documentation, including in procedural accommodation requests. So we're going to talk about accommodation a little later, but a concern might be, by a proponent of the social model, that we're paying too close attention to what the doctor says about an accommodation request, including around maybe a delay in the filing of an application. Right.
Thank you. So let's now take a dive into institutional design, and I want to call on Nina for this first. You work at a tribunal where the focus is on dealing with individuals who have or are alleged to have a mental health or intellectual disability. What processes has the CCB designed to address that, including training? And in dealing with allegations that people are incapable, how does the CCB strike the balance between paternalism, accommodation, and autonomy?
Okay, thank you. So first I'll just describe how does a hearing happen, what leads to one of our hearings. When a person is brought to a psychiatric facility, certain decisions are made. The first 72 hours, the doctors have to sign certain things. There's a lot of paperwork involved, but the first 72 hours, basically, there's no right to appeal or challenge. That's called a Form 1 admission under the Mental Health Act. And then once those 72 hours have expired, the doctor then has to make a decision whether to prolong the detention, and that would be called a Form 3. You don't have to remember that. But as soon as that second form is signed, the statute says that they receive rights advice forthwith. So every patient who's detained has to be met with a rights advisor. That's provided by the Psychiatric Patient Advocacy Office, PPAO. That's a specialized agency under the Ministry of Health, and has nothing to do with our board. But they have people at every hospital, at every psychiatric hospital, providing rights advice to patients. And that's when the patient learns about our process and the ability to challenge the doctor's decision. So the PPAO rights advisor will help them fill out a form that will initiate our hearing. That form gets faxed to the or emailed to the Consent and Capacity Board. And that's day 0 of our 7-day deadline. Usually, the rights advisor will also ask the patient if they wish to have legal representation, and most of the time they say yes. Occasionally they refuse, and I'll get to that a little later. And then if the PPAO rights advisor forgets to ask that, the board will automatically ask Legal Aid Ontario to appoint a lawyer, unless it specifically says on the form, on the application form, the patient wishes to self-represent or patient has their own lawyer. The board will automatically refer it to Legal Aid Ontario to hire a lawyer. So that's how our hearings start. And as I mentioned, they have to start within 7 days of receiving the application. Now, I do want to mention that part of our mandate is to balance competing rights. And this is set out in our mission statement on our website, and it's implicit in the legislation. So the board is responsible for holding hearings and for making decisions on matters in which the least restrictive, least onerous, and least intrusive decisions are made to balance the following interests: maintaining the safety of the individual, protecting the safety of the community, maintaining the dignity and autonomy of the individual, and preserving the right of a person to have treatment when required. So this last one is the one that gets forgotten sometimes when we're balancing autonomy versus public safety. We sometimes forget that people who are unwell also have a right to be treated for their illness, even if they don't necessarily see that it's necessary at that moment, or for some reason they're not able to make that decision. Protecting someone from the ravages of an illness is also a right, I think, in our society. So we do keep that in mind. So I'd just like to talk a little bit about what you asked about maintaining that balance between, I guess, paternalism in a way. Paternalism being, should we be making decisions for an incapable person or letting them make decisions for themselves? So first of all, let's talk about the right to counsel. In the Healthcare Consent Act, it's actually spelled out in Section 81 sub 1, that that's the section that asks Legal Aid Ontario to arrange for counsel, and also says that any person shall be deemed to have capacity to retain and instruct counsel. So this goes back to what Jennifer and Tess were saying, that every person, regardless of their mental condition, has the ability and is deemed to be capable to retain and instruct counsel. That lawyer is representing them. They're not supposed to look at their best interest or the doctor's perspective, or the lawyer's not supposed to be balancing those interests that the board is responsible for balancing. They're only there as a mouthpiece for that patient, and the patient or the applicant has the capacity to instruct them. At the same time, an applicant has the capacity to fire their lawyer, and that's a really important matter as well. And this is something that we struggle with on a daily basis in our work, because as you can imagine, our hearings are a legal process. We deal with evidence. We deal with the burden of proof. We deal with statutory criteria in the acts that create our jurisdiction. And a person is probably better off if they're represented by a lawyer. I would say from my own experience that the applicants are better served if they have a lawyer in most cases representing them. They don't necessarily see it that way, and sometimes their mental disorder in itself creates a suspicion of everybody else, and including their lawyer, or sometimes they just don't like the way the lawyer looks. And they meet with the lawyer and then fire them right away. That does happen. Or they think that they're very capable and can do a better job than the lawyer. That also happens. So when we have unrepresented applicants at our hearings, we have a set of procedures that we follow to make sure that the hearing goes well and smoothly and is fair and thorough. First of all, we don't impose a lawyer on any applicant who states very clearly that they don't want a lawyer. However, we do explain very carefully what the hearing is going to entail, what the statutory criteria are. Sometimes we open up the statute and try to explain it in plain language, exactly what tests we're going to be meeting, what kind of evidence the doctor is going to be providing. We go very carefully and explain the legal process to self-represented applicants. And we also tell them what could be the potential consequences of our decisions. For instance, that they will have to remain in the hospital if we agree with the doctor, or that they will continue to be found incapable. And in the case of incapacity, the statute provides that once our board makes a disposition, they can't reapply for another 6 months. So they will be stuck with that decision for at least 6 months. So after we explain it all really carefully and slowly and in plain language, we ask again, now have you perhaps reconsidered and wish us to appoint a lawyer? And many times they say, yeah, actually, I didn't know it was going to be this detailed or this difficult or this complicated, and now I think I would be better off with a lawyer. So we adjourn the hearing and ask Legal Aid Ontario to appoint a lawyer. But in some cases they say, no, I understand everything and I'm fully confident that I don't need a lawyer. And we proceed. We proceed. That's their prerogative. But we do try to have certain procedures in place. For instance, the doctor has usually provided us with written evidence consisting of clinical notes, perhaps a summary of their notes, discharge summaries from the past, other extraneous matters. And so we make sure that the applicant has a copy of everything that we've had an opportunity to read, and we give them time to read it. Sometimes if their reading ability isn't excellent, we will sit down and read it to them or explain it to them. Or we ask the doctor to summarize all of their evidence orally at the hearing instead of relying on the written evidence. We always provide pen and paper to the applicants. We have extras with us in case. We try to assist with asking questions. So in some ways we change our role to a board of inquiry to make sure that we're inquiring of the doctor all the questions that their legal representative would have asked if they had had one. We offer many recesses, frequent recesses and breaks if they need them. We just try to help that self-represented applicant in any way we can. One thing we always have to make sure of, and this is whether a client is represented or not, we always ask if they're, we ask of the doctor at the beginning of the hearing whether this person is sedated, because sometimes they're receiving medication which sedates them, and the doctors know already that before one of our hearings they must not give them medication that's overly sedating, because we want them to be alert, of course, and be understanding of everything going on. We always use surnames to address our applicants. Even we sometimes have to correct the doctors not to use their first names but use their surnames. We try to speak slowly and use plain language. I know that maybe some people would view these approaches as paternalistic because we're making assumptions about our clients, but I don't think we're making assumptions. We follow their lead. We get to know them at the beginning of the hearing, and we it's a subtle process, but we try to adjust our language depending on how sophisticated or unsophisticated the client is. Some of them are university educated and very articulate, and of course we wouldn't have to make any changes to our language, but sometimes they're not, and we know that we can't use legal jargon. We can't just talk the way we would talk to a lawyer. I do want to mention something about amicus curiae. So sometimes Legal Aid Ontario will have appointed a lawyer for a patient, an applicant, and then when it comes to the hearing, the applicant announces that they've fired their lawyer. They don't feel they can work with this lawyer. But they don't want to adjourn the hearing and get a new lawyer. They want the hearing to go that day, and they say, but I don't need a lawyer. Most of the time, we'll ask that lawyer to stay on as amicus curiae, which means friend of the tribunal. And in that case, we make it very clear the lawyer is not representing the client. They will have the right to ask all their own questions and cross-examine the doctor, but the lawyer is retained as amicus to sort of ensure that fairness is happening and that the board is being very neutral, and it's just kind of there to oversee the process, and we find that very helpful. I also want to emphasize that our board takes our neutrality very seriously. We are there as a neutral arbiter. We're not taking sides on either the doctor's side or the applicant's side. We take that very seriously in our training and in our practice, that that we're not taking sides at all. I think that's the gist of it. Sorry? Okay, then I'll just let you ask questions.
Thank you. Let me turn to Tess in terms of your thoughts on, not necessarily only about the CCB, but system design and how we can design processes to better accommodate people with disability, mental health disabilities, and what we're doing well.
So one sort of set of calls is around specialization, including in the justice system and things like mental health courts. And those calls typically come from, rely on principles of something called therapeutic jurisprudence. And I mean, from my perspective, I would very carefully consider these calls for specialization within the justice system, including admin. And that's in part because, well, to back up, so therapeutic jurisprudence is a set of ideas that kind of maybe call for flexibility or nuance around, rules of general application in order to improve well-being and reduce harm by the process, right? So therapeutic jurisprudence. The name itself is kind of problematic because it sort of implies a medical model, right? Remember I mentioned medical versus social model. And what it means is that judges in these specialized courts, they continue to exercise social control. And critics of TJ, therapeutic justice, would argue that authority is still based on the legal regulation of people with mental health issues is still based on this kind of idea of social control. And the consequence of merging adversarial and therapeutic approaches might mean that offenders spend more time in contact with the criminal justice system, for their benefit, right? It may lead to more intrusive interventions imposed and things like the possibility of coerced consent. So I propose that there are alternatives to the therapeutic jurisprudence approach and other kinds of person-forward, client-centered, but still rights-based approaches. And I mentioned at the beginning trauma-informed approaches to, for example, lawyering, trauma-informed approaches to decision-making. And this focus on trauma is inspired in part by the Me Too movement and thinking about Justice Kavanaugh, and also thinking about new evidence, lots of emergent scientific evidence about the impact of trauma on learning and memory, right? So we know that people with mental health issues are far more likely to be survivors of trauma than people who are not persons with disabilities, including, and that trauma might flow from their interaction with re-traumatizing systems, even those ones that are meant to kind of help. So people with disabilities are 4 times more likely to be a survivor of trauma than people without disabilities, and women with disabilities are 10 times more likely to be a survivor than a woman without a disability. And when I talk about trauma, I'm not talking about PTSD, right? I'm not talking about, instead I'm talking more generally about the impact of an experience of trauma and what it can mean to learning and memory, and how those impacts on learning and memory, what they might mean to assessments of credibility, including in court and admin tribunals, including when survivors, litigants, aren't able to retell their story of trauma or re-traumatization in a linear or easy way.
Tess, how much is that something that's restricted to issues of, or that our solution should be restricted to issues of mental health disability, or should be a general change in how we approach things? Should I, as an adjudicator, just simply assume that anyone before me on any issue may well be a survivor of trauma and change my approach accordingly? Or should we be kind of saying, where there's a mental health issue, this is what we're dealing with?
Including because it's so hard to identify trauma, and in fact the screening for trauma may itself be iatrogenic, may actually be re-traumatizing. Some people do call for universal trauma precautions, just kind of in some cases, maybe in certain kinds of tribunals or with certain kinds of cases, maybe presume trauma.
Most people in the criminal justice system are trauma survivors also.
Yeah, thank you.
Thanks. Jennifer, thoughts on system design?
Well, just thoughts on a few of the different systems. They all have their costs and benefits, right? So the tribunals are faster than the courts, as Nina said. There's more choices, like diversion is always better than fewer options. Diversion can work to connect people with supports and basic human needs like housing that could alleviate or prevent people from being in the state they're in that's brought them to the criminal justice system. And people involved with mental health courts can be more understanding than people involved with the regular courts. And the disadvantage of therapeutic jurisprudence, as Tess said, is it can trample on people's rights. Psychiatric custody is not always preferable, coerced treatment, and it can be more punitive than judicial custody. Like you could end up tied to a stretcher, being medicated against your will, for example. There was a man who went to mental health court, very, very, very minor charge. He was required to see his psychiatrist, so he pounded his fist on the psychiatrist's desk, so the psychiatrist issued a Form 1 on him, and he was taken to the hospital. He was dragged out of his apartment while he was making dinner, taken to the hospital against his will. He was extremely upset. He ended up being put in restraints, so nobody was allowed to see him. He didn't get his hearing because he was in restraints. He became suicidal. It's just complete disaster. Would have been much better if he'd just gone through the judicial system. He was actually locked up for doing this to some police officers, so not exactly a danger to the public. The drug court can be a great option to the criminal justice system, but the requirements of it can be so rigorous that it's really, really likely that somebody will fail. And keeping the requirements also means that people can't, for example, keep a job, or at least it's very difficult to have a job and appear in court every day for a set period of time. ORBs can overreact to a non-dangerous non-compliance. They can also be good, for example, we've had them rule on how a hospital is regularly violating the requirement to tell them that somebody's in increased custody because they're in seclusion for long periods of time and the ORB has not been informed. Trouble is, the ORB doesn't have anything much they can do about that, even when they chastise the hospital. The CCB can disregard the person's perspective in favor of medical opinion. There was, for example, a self-representing person who asked for the right to have a break so he could get outside for his one time outside all day long. He was given the right, but then they decided to hold the rest of the hearing in his absence. So they were actually rebuked by the court for doing that. It's good if a lawyer can predict an outcome, for example, of a person testifying and give them that informed sort of information so they can make a good decision. But of course, a lawyer doesn't always know, so they can just give their best opinion. I remember a case of somebody who was in trouble for giving some drugs to somebody else, and they referred to him as having antisocial personality disorder, and he said, No, I'm very social. That's why I share my drugs. Maybe not the best thing for him to have said under circumstances, but it's hard to predict that's what was going to come up.
Thank you. So I'd like to now to move to our last big theme before we move to some of the questions from the participants. And that's about how we deal with incapacity and supportive decision-making in regimes kind of outside those that are set up specially to do that, like CCB, NCR regimes, and so on. So in most tribunals that don't deal exclusively with mental health, there's no formal structure to deal with litigants who may be incapable or need support. Tess, can you tell us about those challenges and what solutions have been developed? And in developing innovative regimes for modern tribunals, what are alternative approaches that can be used, like supportive decision-making?
Right. Thank you, David. So just right back to first principles, we know that people with mental health issues are more likely to, their rights are more likely to be at stake in an admin tribunal. But they still face these barriers to administrative justice. And one of the barriers, as mentioned, that they might face are barriers around the accessibility or difficulties that they might have in understanding and appreciating information about the case. And some disabilities, including just some kinds of mental health issues, not all of them certainly, can make a person unable to make certain kinds of decisions around litigation for at least a period of time. But it is more often, to be clear, that prejudice and stereotypes can leave some people to believe that they're not able to make those decisions, right? So to deal with this problem of persons with disabilities who aren't able to make these litigation decisions, some tribunals have permitted applications from substitute decision makers, including folks who have continuing power of attorney or a court-appointed or statutory guardian of property. But there's problems with this approach, right? And that's because the appointment of guardians, including court-appointed or statutory guardians, they're invasive and they last for far longer than the litigation itself, right? And then it impacts the decision-making authority of the person to make other kinds of decisions rather than outside of the litigation itself. So the problem is, how can the right of a person with a capacity issue have her case heard before a tribunal without having to resort to these long-lasting, invasive guardianship types of proceedings? So one way that has happened, is, most tribunals have adopted kind of ad hoc kind of arrangements. So the appointment of amicus, we talked about the appointment of amicus before. There is a line of very exciting HRTO, Human Rights Tribunal of Ontario cases about the tribunal's authority to appoint litigation guardians. And that line of cases relies, at least in part, on the UN Convention on the Rights of Persons with Disabilities. The UN Convention on the Rights of Persons with Disabilities. So for the most part, those are all kind of like ad hoc arrangements. What happened, though, is in 2003, the social justice tribunals of Ontario, a cluster of tribunals that include the LTB, the SBT, and the HRTO, not the CCB.
2013,
2013.
Just to be, you said 2003, so I just wanted
sorry. Yeah, 2013. So a practice direction on litigation guardians in SJTO tribunals. And that practice direction sets out, as the law does, that everyone is presumed to be capable of making decisions, including decisions around commencing a claim. All right, so everyone who's 18 plus is presumed to be capable. And I think Nina mentioned that's enshrined also in law, and that's a clear first principle. And so this practice direction also sets out things like that someone can step in the person's shoes and help them make decisions and take on the role of a litigation guardian. Now, interestingly, the HRTO, or tribunals in the SJTO, they can't require a litigation guardian to act, and that's different from the the appointment in court of a litigation guardian, and where the court can require the appointment of the public guardian and trustee and the children's lawyer. The process or the practice direction sets out that there must be a process where the litigation guardian, who must be willing to act, must be him or herself capable, right? Must be 18 plus. And they must also set out or make declarations around conflict, if there's any sort of appearance of conflict between their interests as litigation guardian and the person who's at the center of the litigation, right? So the practice direction 2013 from the SJTO. What's really also striking about that practice direction is that it is very clear at the end that the appointment of a litigation guardian must only be made as a very last resort after, for example, considering whether there was any form of accommodation that could have supported the person at the center of the litigation to have made decisions by him or herself. Just because you need support or accommodation doesn't mean that you can't make your own decisions. So there may be some form of accommodation, even something creative or innovative, that may allow the person at the center of the litigation to make their own decisions without the appointment of a litigation guardian.
Thank you. Nina, do you have, I know in your tribunal, obviously, there's a special regime that allows people who would be incapable in a different situation to self-represent or instruct a lawyer. What are the challenges of that, and what are the advantages?
Well, I've described some of them. I think the advantage is autonomy. I mean, the right to decide for yourself if you want to have a lawyer or not. The disadvantage is that your case might not be presented as ideally as it would be by a lawyer. I do want to address Tessa's points, though, because I think it's a really interesting approach, this supportive decision making. But unfortunately, the way our legislation operates right now, it's all or nothing. If a person is found incapable, another person is making decisions on their behalf. We don't have a legal framework for supportive decision making at this time. I do want to point out, though, that in the case of treatment decisions, for instance, or admission to a long-term care facility, if a person does not like who their substitute decision maker is, they can apply to have a different substitute decision maker. So it's called Form B under the Healthcare Consent Act, and a person can apply and has to have a hearing to determine whether the person that they're nominating would be an appropriate decision maker. And I have had cases like that have been successful. I also want to point out, though, that the reason we hold a hearing and we don't allow that to automatically happen is that there's potential for exploitation of vulnerable people by substitute decision makers, and we have to be very cognizant of that as well, that a person who is experiencing mental disorder might be open to exploitation or poor decision making by a friend or an acquaintance who says they'll step in and be their decision maker, but the board has certain processes in place, and we hold a hearing and we need evidence to make sure that that person that they're nominating will be an appropriate decision maker. Yeah, I'll leave it at that.
Thanks.
Yep.
Jennifer, any comments on this issue?
Just a little. I think Tess covered a lot of what I was thinking. Actually, in Hansard, the one time that we were able to get the legislation to comply with what we wanted was that the government quoted us when creating the right of people who are found unfit to stand trial to be able to get a stay of proceedings. So that was one success we had, legislature. People First is actually an organization that is created by and for people with developmental disabilities. And they have a long practice of supported decision making that I think is an excellent model. And I've found that when people are found unfit to stand trial, there's often been an assumption that if you medicate people sufficiently, they're going to understand the judicial process. And people aren't born understanding the judicial process, and some of them are immigrants to the country, and they have no way of having known what the judicial process is. Late Justice Ormston used to give a wonderful example of how he would assess fitness, he'd say to somebody, "Do you understand, who this crown attorney is?" He goes, "Yeah, he's a shithead. He's going to be just trying to lock me up." And who's this guy? The one standing next to you goes, "He's a mouthpiece. He's going to be speaking in front of me." And who am I? He goes, "You're the fat fuck who's going to be ruling on my case." And he had to rule fit. Seems to understand the process. I loved it as an example of someone who didn't get all bent out of shape about somebody's language, and whether they personally felt insulted, but instead was able to just extract the necessary information from what the person was saying. He used to talk to my classes when I was teaching criminal justice system at Humber. He was great. And it's it's part of decision making, so it's not so black and white. And sometimes it's a very difficult call whether somebody needs somebody else to judge their situation or not. I certainly there have been situations where people on community treatment orders, for example, have had somebody as their SGM who was an abusive family member and were unsuccessful at getting them off the file because it was treated as some kind of symptom that they said they were an abusive family member. So that's one of the worst results that can happen.
So what if we were to put into place a better regime of supported decision making, what would it practically look like in terms of this middle ground between you make all your own decisions and you make none of your own decisions? Is it obligations of consultation between the substitute decision maker and the person? Is it splitting of decision making? Can you talk a little bit more about what that would mean if we redesigned that regime?
Well, I think it requires that we think creatively about regimes and maybe look to other jurisdictions. I know, for example, in BC, they have a system of representation agreements, and other provinces have done it differently, and they've found a way to kind of make it work, keeping in mind concerns around vulnerability to abuse. I think also sort of overlaying all of this is I mentioned it before, the UN Convention on the Rights of Persons with Disabilities. And one of the articles, Article 12, requires that people, regardless of their disability, be provided with the support that they need. So it is very clear that people deserve the support to make their own decisions, right? They're entitled to that support. It is, as we say, a right.
Thank you. So I'm going to go a little off script, and before we move to our next question, take a few questions from the audience and from the webcast. So someone who's watching on the webcast asked this. As a paralegal who focuses on a clientele with PTSD and anxiety issues within the tribunal system, I find medical professionals have difficulty describing the accommodation needs of mental health disabilities within the social areas to enforce the client's human rights. How do you propose this barrier be addressed systemically? And I'm guessing that's probably a question for Tess first.
Can you repeat the second half of that?
Sure. So medical professionals have trouble describing what the needs are of someone with mental health disabilities. So I think it's, as I take the question, it's that, the sort of standard thing that lawyers ask people is, can you describe their limitations, describe what their needs are, and we expect doctors not to tell us what to do as service providers, but we expect doctors to clearly describe their needs. So how do we address that? Where I think the questioner is saying it can be really hard for doctors to know how to do that in a lingo that's going to work for lawyers and employers.
Right, I think that's really thoughtful that in fact it's not up to the doctor to make the decision about what form of accommodation would work for the person's individual disability-related needs, because of course accommodation decisions need to be made precisely and individually. There's no such thing as a one-size-fits-all approach. Sometimes tribunals or even service providers are kind of driven to provide, things like more, a one-size-fits-all approach, like breaks, extra time, that kind of stuff. But I think it does require that doctors think big, or at least we allow them to sort of think big and offer maybe some more education about the types of accommodations that are available, including really creative ones, including things like the availability of written questions or written materials ahead of time, the taking of testimony by video, for example, that kind of stuff, sort of creative, innovative examples of accommodation.
And as a former human rights adjudicator, I think, I think what's really, it is a hard thing to ask doctors to do, but we ask them to kind of straddle the line between, because it's not helpful when a doctor just says, my patient needs blah. On the other hand, we understand, and human rights law understands that, we're not, an employer, for example, or a service provider is not entitled to a diagnosis. And so it's a translation, it seems to me, between medical and legal language. And the best thing the doctor can do, it seems to me, is to just describe in everyday language, to the extent possible, what this person's disability means for them, right? So it's not about saying, this person needs breaks necessarily, but it's about, I think for lawyers and paralegals to direct doctors to say, this person's disability means they have difficulty concentrating, means that from time to time this may happen, and they need, the accommodations will address these particular issues, and I think it's it's frustrating as someone who's certainly in relation to accommodation in hearings when a lawyer or paralegal just says, well, this person needs an adjournment of their hearing. That's not enough for us to evaluate it. But if they say, they have these issues and more frequent breaks and understanding all of that, and I appreciate there's a balance there with privacy as well, but I think it's getting doctors out of medical speak and lawyers out of lawyers speak, in my view.
I was going to say, may I add to that?
Yeah, go ahead.
I was going to say that, very clearly we don't tie a diagnosis to the request for accommodation. That is clearly not correct. But I did want to kind of point out the availability of maybe a creative type of accommodation. So there may be certain people with certain kinds of mental health disabilities that maybe they're survivors of trauma, where they might have trouble communicating. And that might be because maybe the formality of the process interferes kind of with their ability to understand and appreciate, right? There's something about the process that makes it hard for them to communicate. So you might, for example, want to look to an organization called Communication Disabilities Access Canada, cdacanada.org, and they have a roster of speech-language pathologists who can act as communication intermediaries. So it's not, you may want to explore the availability of an accommodation that includes something like a communication intermediary, and they could, for example, support your client, if you're a lawyer, to understand questions or give answers effectively, to kind of translate or interpret the language of the justice system for a person with a disability who has communication issues. cdacanada.org.
Or Jennifer, did you want to comment on the accommodation question?
I think Tess covered most of what I'd say. Just that when considering needs, of course, asking the person what their needs are, using their language sometimes, always to be recommended.
So another question from our audience on the web. Clients with mental health holds who are held under the Mental Health Act are unable to reach a legal advisor other than between 9 a.m. and 4:30 p.m. Monday through Friday. This leaves mental health clients with no contact to the outside world for most of the work week and over weekends. Do you see this as an access to justice issue? Jennifer?
I do. A weekend is a very long time to spend without access to justice. Losing someone's liberty is not a minor matter. So I think there should be 7-day-a-week access to justice. By the way, I meant to say earlier, you were mentioning that the rights advisors come from the PPAO. That's mostly true, but it's not always true anymore. The previous Conservative government told the psychiatric hospitals they didn't have to employ the PPAO anymore. So And general hospitals don't always, so sometimes they'll have something like a security guard who gives somebody rights advice. Obviously better if it's the PPAO, which is a sort of quasi-independent body funded by the Ministry of Health.
Actually, I wasn't aware of that. Thank you.
Well, let's obviously encourage people to continue to ask questions, but let's go back to a couple of the questions we had planned, and please continue to send in or write your questions on cards. One of the significant themes we've discussed throughout today is how the law can empower, accommodate, and support people with mental health disabilities without being paternalistic, and while also supporting recovery where that's appropriate as well. In designing processes and legal institutions that address mental health, do you have some final thoughts on how we should strike that balance, and how do we train decision makers and advocates to strike that balance? Why don't I start with you, Nina, in particular on the training point?
Well, I think that despite what some of the comments I've heard today, I actually think the Consent and Capacity Board is very successful at striking that balance, and that we can serve as a role model to other tribunals and perhaps even the courts in terms of providing accommodations to people with mental disabilities or a mental disorder. So as I mentioned, we have a very lengthy and detailed training process, which includes a half-a-day sort of lecture by a psychiatrist that's on our board, who describes to all the other types of members, the lawyers and the public members. It's like a crash course in psychiatry and the different types of conditions and the medications. And so we do get a little bit of education from the medical perspective, and we also hear from survivors. But a lot of it is really based on just understanding the law and the framework and our process and how we can deliver fair and thorough hearings. I think, in terms of what can we be doing better, in terms of my role as an adjudicator, I think in the case of a self-represented party, it might be helpful if we could be more of an inquisitorial body rather than an adjudicative body, and maybe not maintain so much neutrality and try and actively elicit the evidence from the unrepresented party and try to sort of act as in a more supportive role for that party. I mean, right now our adversarial model is pretty strict in Canada, and it's hundreds and thousands of years of common law jurisprudence that we're following, but maybe we could modify it a little to be a bit more, we're trying, but I think we could go even further in being a little bit more proactive and less perhaps neutral. Another possibility would be to have some kind of duty counsel available, funded by Legal Aid Ontario, that would come and attend our hearings even if a person didn't want to have legal counsel, just as we have amicus curiae. I also want to mention that our hearings are open to the public, and on any given day there's multiple hearings in Toronto that you can attend if you wish to sort of see in action how we accommodate our parties. They take place in hospitals for the most part, because that's where the applicants are. But you can call the board on any given day and ask them for the docket for the next day. We only know one day in advance where our hearings are going to be because the schedule fluctuates so much from day to day. But they are open to the public, and also you could visit our website at ccboard.on.ca and learn a lot more about our processes. There's even some kind of simulated hearings. We have videos of simulated hearings with actors, but we'll give you an idea of how our hearings unfold and how we try so hard to accommodate our parties.
Jennifer?
I'm alarmed at the prospect the CCB would be more supportive of doctors. It's already very rare for somebody to win a CCB hearing.
Wait, did I say that?
I thought that's what you were saying. You're going to offer more assistance to unrepresented parties.
No, I'm sorry. I meant only the applicants.
Oh,
I didn't
great.
mean the doctors.
Thank you.
No,
Okay.
no.
Good.
Okay, fair enough.
That would be
Thank
nice.
you for that correction. No.
Thanks. Okay, good then. There is, as I said, evidence that giving people what they say they need is actually more effective than imposing it. So that, if everything took that into account, that would be great. And people's needs can't always be realized, but it's certainly helpful for them to be heard. I wrote a chapter in a book once called What Do Rights Have to Do with Trauma-Informed Care? And everything. What happened? Some of the things that happen to people in the mental health system would be one of the more horrific crimes if they happened to somebody who wasn't in the mental health system. And there's no reason to think that people find them less traumatizing because they're a mental patient. Being tied to a stretcher for days, being medicated against your will, these are incredibly traumatic things. And even in the discussions of trauma-informed care, they're often referred to as triggers of trauma, but they're in fact independently traumatizing. And I'm not saying I don't understand why sometimes people are removed from other people, but really has to recognize how damaging they can be. It's important for LAO to keep supporting the voice of people with lived experience, for the council to be alert to concerns about case law that arises that might give an opportunity to create good case law around rights. People involved with the Mental Health Legal Committee and Lambda have been great about doing that. I'd ask lawyers, see if I can get that back on to people's attention, the sheet we created on what you can expect from your lawyer. It'd be great if that went out to people. I think there's some room for restorative justice models to be considered in the mental health law. And it's just generally recognized that rights aren't antithetical to treatment. They're actually a necessary component of somebody's experience. So advice for counsel representing people with lived experience, some advice I'd have would be listen. Understand that people have their own ideas on what's important to them, and it's not always what would be obvious to you. It might not be your idea what's important to them or their doctor's idea, but it's that person's idea. And when the concept of client-centered care was first introduced at ChemH, a psychiatrist said, well, they'd be so much better off if they just did what I told them to do. I said, yeah, if they were living their life, or your life, but they're actually living their own life. So everybody has their own priorities and ideas of what's fulfilling. CCB and ORB should have consultations and advisories of people with lived experience in the mental health bar just as much as they do with physicians and their counsel. Anyone who's interested can also assist me in my goal, my life goal of creating a national mental health legal advocacy center. There's one in the U.S. Canada doesn't have one. I think we really need one. The rates in mental health across the country are an incredible hodgepodge of lesser and greater rights. I was examining it recently, for example, and people's rights related to restraint are all over the place, and I think there needs to be coherence and compliance with the Charter.
Thanks. Tess?
I'm struck by that word, the hodgepodge, right? Like, because there is so much really amazing, exciting work around rights and mental health going on around the country. I'm thinking about, there's a charter challenge right now in BC.
Really?
Yeah, so cool. That one is about the fact that when you are detained under the Mental Health Act in BC, you are presumed to be incapable of making decisions. So right. So really fantastic work challenging the constitutionality of that provision in BC's Mental Health Act. So yeah, the idea of undoing kind of that hodgepodge with this national center would be absolutely fantastic. Including because maybe we also need to cooperate to challenge some of these systemic barriers that we've, that you've all highlighted, including around access to legal aid, including who pays for accommodation, right? Who pays for the extra time that, for example, is required to prepare your client for a case before an admin tribunal, right? Who pays for that? It certainly can't be, the cost of accommodation can't be something that you charge back as a disbursement to your client, okay? I was, though, going to say that all of this certainly starts in law school. There's something about the way that we train law students that we need to get in there right at the beginning. So I think we do something now. We still teach law students to remain emotionally detached, to focus on the facts. And I think that interferes at the end of the day with trust building, creating a sort of a sense of safety. It may also interfere with adoption of those trauma-informed approaches that I mentioned before that are just so important. It may also be that we want to train our decision makers around trauma-informed approaches and the impact of trauma on learning, for example, and also the impact of trauma on themselves, the impact of vicarious trauma. So it may be that that hearing about trauma as a decision maker has an impact in the form of secondary or vicarious trauma on the decision maker.
Just to pick up on that point, one of the things that I've been struck with as someone who spends a lot of the time on training of decision makers is that I think we could do a lot better on how we think about training on mental health issues. We've done not a bad job, I think, in certainly in the administrative justice community, and getting people to understand the need for accommodation, getting people to understanding the nature of mental health issues. But I've been to way more sessions where I learned about what the possible diagnoses are than I have learning about how trauma influences people. And I think there's something very important there in terms of how we think about the training that we offer.
May I just make
Yeah,
a
of
few points?
course.
Sorry, I just thought of a couple of things. I don't want to mislead everyone. I do want to point out that it's a very small percentage of our hearings where the applicant does not have representation. I'd say in about 95% of our hearings, the applicant does have legal counsel. I do find, though, that there's a pretty wide disparity among the abilities of the legal counsel and their experience in coming before our board and dealing with their clientele and also the legal issues. So I think perhaps the Law Society and perhaps the Bar Association could up their game in terms of training lawyers, especially lawyers accepting legal aid. And I do also want to mention that we don't always decide in favor of the doctor. I would say that perhaps 20 to 25% of our cases are decided in favor of the applicant. That's anecdotal, it's not a statistic. But even if we do decide in favor of the doctor, I think it's important that a lot of applicants feel they've been heard and that an independent body has reviewed the doctor's decision. I think that gives them some level of satisfaction, and sometimes the doctors too feel gratified that they're not alone there and that there's someone overseeing their decision making and that there's evidence bearing up their decisions.
I'm not sure if there are cards, but if whoever has them can bring them up at some point, that would be great. I want to pick up on one question that we have from the internet. The question is about dementia, and the question itself says, is the Alzheimer's Society correct when they say that there is an addition to the Charter of Rights called Canadian Charter of Rights for people with dementia? The Charter of Rights hasn't been amended. I don't know whether there was something created for folks with dementia, but I also just wanted to ask about how the particular issues around dementia play out with some of these issues in terms of people who obviously lose their capacity as they age and perhaps know that's coming. I don't know who I should start with.
I'll start,
Nina.
and I'll just say anecdotally that a large portion of our applicant pool is people with dementia, very large. I don't know the statistics, and I wouldn't even want to put a number on it. I don't think anyone's capable of doing that. But yes, it's a significant amount of our work.
So how does that differ? Because we sometimes lump all mental health and intellectual disabilities together, which is probably a mistake. Well, it is a mistake. They have commonalities, but what are the specific things around Alzheimer's and dementia that we need to take into account?
I think it requires some very special thinking around, for example, supported decision-making, access to accommodations, and I'm thinking in particular about the Law Commission's recent work on law as it relates to older adults, and would definitely draw some inspiration from their important work, including around decision-making.
I don't have much to say about it other than that most of the people I see don't have anything to speak of in the way of resources, where I suspect that people who have dementia, property capacity might be more of an issue because they might have property to lose, and so having a conflict of interest in who's your substitute decision maker would be more important to examine.
So some of the questions that we've gotten from the audience are really focused around licensees, all kinds of licensees in terms of serving their clients. And maybe, I know you've talked a little bit about that, but in terms of, we spoke a little bit about adjudicator training. What is important in particular in this area for licensees to keep in mind? And, you said you wrote a page on what persons should expect from their lawyer. If you were flipping that around, what would it say about what lawyers should remember when they're dealing with a client with a mental health disability? Or, and maybe I'll add to this, a possible mental health disability, because that's the other area of challenge, is that sometimes professionals may assume, may guess, may be right, but how do we bring that up as professionals with our clients?
I wish I had remembered. I meant to bring that tip sheet with me, and there actually was one for guiding lawyers as well. They both came. I was on the Mental Health Advisory Committee at LAO, so I can make those available and you can post them. But things like taking time with people, it's going to take maybe more time to talk to them and understand what they have to say. Meeting with people before the hearing helps a lot, especially if it's like not right before is ideal. But I know that the legal aid funding, frankly, is so small that it's difficult for people to take a lot of time, and people's files are sometimes enormous. So part of it is that I know when people are lawyers, they often feel that they have an idea of the best outcome. Well, everybody tends to have that idea about their own thoughts, but as I said, the person themselves might have their own priorities, and they might be quite different. Sometimes they might prioritize some small thing that doesn't even have to do with their own liberty. You don't know unless you listen to the person about what's most important to them.
I would add to that the importance of training around intersectionality.
Oh, good.
Right, because we need to do a better job of confronting the complex ways that people with mental health issues confront discrimination. I'm thinking in particular about the experiences of discrimination by women with mental health issues, Indigenous people with mental health issues, and maybe this is relevant also to the experience of older adults with mental health issues who may have also experiences of dementia or be diagnosed. Right.
I also think everybody should be getting some training on how to relate to people who have histories of trauma, because the vast majority of people in the mental health and addiction system and criminal justice system are survivors of trauma. We actually, I teach the police who are involved with the mobile crisis intervention team in Toronto on trauma-informed crisis calls. There's quite a lot of information available right now that might help also maybe CCV members or B members, because it does have an effect on how people process information and how people behave and what's important to them and what can make hearings more or less frightening.
What about that issue of a lawyer or paralegal who's concerned their client may have a mental health issue, but obviously we're not doctors and can't diagnose? How do we rate? Obviously, I assume the answer is not call the police. The answer is not send them to the hospital. What is the answer, or what answers are there?
I think you said it before. Just ask them, right? Ask them what they need.
Right.
The accommodation.
But how do you ask it while
Right.
raising the mental health issue, right? Because do we say, if somebody someone comes into our office and, has some, say, symptoms that may suggest some disconnection with reality.
Right.
What's our role? I mean, if you just ask them,
Right.
they might say, please stop this thing from happening. How
Right.
do we,
Yeah.
if at all, relate to that issue?
Right. I was thinking that a lot of the accommodations that we've talked about already, they are examples of universal design, that they could actually just help anyone, be supportive of anyone and their access to administrative justice. So, in fact, you don't actually need a reason to accommodate people in the ways that they need to. It may be that you just ask them what they need, and you can arrange the administrative justice process in a way that is maximally inclusive to all people, whether or not they have a disability or not, or they say they have one but they don't really, or they do and don't, right? So taking a universally designed approach to administrative processes.
Any final comments from any of our panelists?
I'm glad that there's a concern for people to learn more about mental health law. I think, as Nina said, there's a great disparity in how well people know it, including people who sometimes appear before the board. So well done, everybody, for self-educating.
Thank you. Thank you all for your participation. It's been a very rich discussion of a whole bunch of different aspects of this issue, and thanks to everyone for your questions and comments. We will continue the discussion in many other places, but back here at TAG, hopefully next year for Access to Justice Week 2019. So thanks, everyone. Thanks to all of you.